of India, Part 9A, the municipalities, Article 243P to Article 243ZG. Article 243P, definitions. In this part, unless the context otherwise requires, committee means a committee constituted under Article 243S. District means a district in a state. Metropolitan area means an area having a population of 10 lakhs or more, comprised in one or more districts and consisting of two or more municipalities or panchayats or other contiguous areas specified by the governor by public notification to be a metropolitan area for the purpose of this act. This part. Municipal area means the territorial area of a municipality as is notified by the governor. Municipality means an institution of self-government constituted under Article 243Q. Panchayat means a panchayat constituted under Article 243B. Population means the population as ascertained at the last preceding census of which the relevant figures have been published. Article 243Q, Constitution of Municipalities. There shall be constituted in every state a Nagar Panchayat, by whatever name called, for a transitional area. That is to say, an area in transition from a rural area to an urban area. A municipal council for a smaller urban area and a municipal corporation for a larger urban area in accordance with the provisions of this part. Provided that a municipality under this clause may not be constituted in such urban area or part thereof as the governor may, having regard to the size of the area and the municipal services being provided or proposed to be provided by an industrial establishment in that area, and such other factors as he may deem fit by public notification specified to be an industrial township. In this article, a transitional area, a smaller urban area or a larger urban area means such area as the governor may, having regard to the population of the area, the density of the population therein, the revenue generated for local administration, the percentage of employment in non-agricultural activities, the economic importance, or such other factors as he may deem fit, specify by public notification for the purposes of this Act. Part. Article 243R. Composition of municipalities. Save as provided in Clause 2. All the seats in a municipality shall be filled by persons chosen by direct election from the territorial constituencies in the municipal area, and for this purpose each municipal area shall be divided into territorial constituencies to be known as ward. The legislature of a state may by law provide for the representation in a municipality of persons having special knowledge or experience in municipal administration. The members of the House of the People and the members of the Legislative Assembly of the state representing constituencies which comprise wholly or partly the municipal area. The members of the Council of States and the members of the Legislative Council of the state registered as electors within the municipal area. The chairpersons of the committees constituted under Clause 5 of Article 243S. Provided that the persons referred to in paragraph 1 shall not have the right to vote in the meetings of the municipalities. The manner of election of the chairperson of a municipality. Article 243S, Constitution and Composition of Wards Committee, etc. There shall be constituted wards committees consisting of one or more ward within the territorial area of a municipality having a population of 3 lakhs or more. The legislature of a state may by law make provisions with respect to the composition and the territorial area of a ward committee, the manner in which the seats in a ward committee shall be filled. A member of a municipality representing a ward within the territorial area of the ward committee shall be a member of that committee. Where a ward committee consists of one ward, the member representing that ward in the municipality. For 2 or more wards, one of the members representing such wards in the municipality elected by the members of the wards committee shall be the chairman of that committee. Nothing in this article shall be deemed to prevent the legislature of a state from making any provision for the constitution of committees in addition to the wards committees. Article 243T, Reservation of Seats. Seats shall be reserved for the scheduled caste and scheduled tribes in every municipality, and the number of seats so reserved shall bear, as nearly as may be, the same proportion to the total number of seats to be filled by direct election in that municipality, as the population of the scheduled caste in the municipal area or the scheduled tribes in the municipal area bears to the total population of that area, and such seats may be allotted by rotation to different constituencies in a municipality. Not less than one-third of the total number of seats reserved under Clause 1 shall be reserved for women belonging to scheduled caste or, as the case may be, the scheduled tribes. Not less than one-third, including the number of seats reserved for women belonging to the scheduled caste and scheduled tribes, of the total number of seats to be filled by direct election in every municipality shall be reserved for women, and such seats may be allotted by rotation to different constituencies in a municipality. The offices of chairpersons in the municipality shall be reserved for the scheduled castes, the scheduled tribes, and women in such manner as the legislature of a state may by law provide. The reservation of seats under Clause 1 and 2 and the reservation of offices of chairpersons other than the reservation for women under Clause 4 shall cease to have effect on the expiration of the period specified in Article 334. Nothing in this part shall prevent the legislature of a state from making any provision for reservation of seats in any municipality or offices of chairpersons in the municipalities in favor of backward class of citizens. Article 243U, Duration of municipalities, etc. Every municipality, unless sooner resolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting, and no longer, provided that a municipality shall be given a reasonable opportunity of being heard before its dissolution. No amendment of any law for the time being in force shall have the effect of causing dissolution of a municipality at any level which is functioning immediately before such amendment till the expiration of its duration specified in Clause 1. An election to constitute a municipality shall be completed before the expiry of its duration specified in Clause 1, before the expiration of a period of 6 months from the date of its dissolution, provided that where the remainder of the period for which the dissolved municipality would have continued is less than 6 months, it shall not be necessary to hold any election under this clause for constituting the municipality for such period. A municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period for which the dissolved municipality would have continued under Clause 1 had it not been dissolved. Article 243B, Disqualifications for membership. A person shall be disqualified for being chosen as and for being a member of a municipality if he is so disqualified by or under any law for the time being in force for the purposes of elections to the legislature of the state concerned, provided that no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. If he is so disqualified by or under any law made by the legislature of the state. If any question arises as to whether a member of a municipality has become subject to any of the disqualifications mentioned in Clause 1, the question shall be referred for the decision of such authority and in such manner as the legislature of a state may by law provide. Article 243W, Powers, authority and responsibility of municipalities, etc. Subject to the provisions of this Constitution, the legislature of a state may by law endow the municipalities with such powers and authority as may be necessary to enable them to function as institutions of self-government, and such law may contain provisions for the devolution of powers and responsibilities upon municipalities, subject to such conditions as may be specified therein with respect to preparation of plans for economic development and social justice, The performance of functions and implementation of schemes as may be entrusted to them, including those in relation to the matters listed in the 12th schedule. The committees with such powers and authority as may be necessary to enable them to carry out the responsibilities conferred upon them, including those in relation to the matters listed in the 12th schedule. Article 243X. The power to impose taxes by the funds of municipalities. The legislature of a state may, by law, authorize a municipality to levy, collect, and appropriate such taxes, duties, tolls, and fees in accordance with such procedure and subject to such limits. Assign a municipality such taxes, duties, tolls, and fees levied and collected by the state government for such purposes and subject to such conditions and limits. Provide for making such grants in aid to the municipalities from consolidated fund of the states, and provide for constitution of such funds for creating all monies received respectively by or on behalf of the municipalities, and also for the withdrawal of such monies therein as may be specified in the law. Article 243W. Finance Commission. The Finance Commission constituted under Article 243I shall also review the financial position of the municipalities and make recommendations to the governor as to the principles which should govern the distribution between the state and the municipalities for the next proceeds of the taxes, duties, tolls, and fees leviable by the state, which may be divided between them under this part, and the allocation between the municipalities at all levels of their respective shares of such proceeds. The determination of the taxes, duties, tolls, and fees which may be assigned to or appropriated by the municipalities. The grants in aid to the municipalities from the consolidated fund of the state. The measures needed to improve the financial position of the municipalities. Any other matter referred to the Finance Commission by the Governor in the interest of sound finance of the municipalities. The Governor shall cause every recommendation made by the Commission under this article, together with an explanatory memorandum as to the action taken thereon, to be laid before the legislature of the state. Article 243Z. Audit of accounts of municipalities. The legislature of a state may by law make provisions with respect to the maintenance of accounts by the municipalities and the auditing of such accounts. Article 243ZA. Elections to the municipalities. The superintendent's direction and control of the preparation of electoral rolls for and on the conduct of all elections to the municipalities shall be vested in the State Election Commission referred to in Article 243K. Subject to the provisions of this Constitution, the legislature of the state may, by law, make provision with respect to all matters relating to or in connection with the elections of the municipalities. Article 243ZD. Application to Union Territories. The provisions of this part shall apply to the Union Territories and shall, in their application to a Union Territory, have effect as if the references to the Governor of a state were references to the Administrator of the Union Territory, appointed under Article 239, and the references to the Legislature or the Legislative Assembly of a state were references in relation to a Union Territory having a Legislative Assembly to that Legislative Assembly. Provided that the President may, by public notification, direct that the provisions of this part shall apply to any Union Territory or part thereof, subject to such exceptions and modifications as he may specify in the notification. Article 243ZC. Part not to apply to certain areas. Nothing in this part shall apply to the scheduled areas referred to in Class 1 and the tribal areas referred to in Class 2 of Article 244. Nothing in this part shall be construed to affect the functions and powers of the Darjeeling Gorkha Hill Council constituted under any law for the time being in force for the hill area of the district of Darjeeling in the state of West Bengal. Notwithstanding anything in this constitution, Parliament may by law extend the provisions of this part to the scheduled areas and the tribal areas referred to in Class 1 subject to such exceptions and modifications as may be specified in such law, and no such law shall be deemed to be an amendment of this Constitution for the purposes of Article 368. Article 243 ZD. Committee for District Planning. There shall be constituted in every state at the district level a district planning committee to consolidate the plans prepared by the panchayats and the municipalities in the district, and to prepare a draft development plan for the district as a whole. The legislature of a state may, by law, make provisions with respect to the composition of the district planning committees, the manner in which the seats in such committees shall be filled, provided that not less than four-fifths of the total number of members of such committee shall be elected by and from amongst the elected members of the panchayats at the district level and the municipalities and district in population to the ratio between the population of the rural areas and the urban areas in the district. The functions related to district planning which may be assigned to such committees. The manner in which the chairpersons of such committee shall be chosen. Every district planning committee shall, in preparation the draft development plan, have regard to matters of common interest between the panchayats and the municipalities, including the spatial planning, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation, the extent and type of available resources, whether financial or otherwise. Consult such institutions and organizations as the governor may, by order, specify. The chairperson of every district planning committee shall forward the development plan as recommended by such committee to the government of the state. Article 243 ZE. Committee for Metropolitan Planning. There shall be constituted in every metropolitan area a metropolitan planning committee to prepare a draft development plan for the metropolitan area as a whole. The legislature of a state may by law make provisions with respect to the composition of the metropolitan planning committees, the manner in which the seats in such committees shall be filled, provided that not less than two-thirds of the members of such committee shall be elected by and from amongst the elected members of the municipalities and chairpersons of the panchayats in the metropolitan area in proportion to the ratio between the population of the municipalities and the panchayats in that area. The representation in such committees of the Government of India and the Government of the state and of such organizations and institutions as may be deemed necessary for carrying out the functions assigned to such committees. The functions relating to planning and coordination of the metropolitan area which may be assigned to such committees. The manner in which the chairpersons of such committee shall be chosen. Every metropolitan planning committee shall, in preparing the draft development plan, have regard to the plans prepared by the municipalities and the panchayats in the metropolitan area. Matters of common interest between the municipalities and the panchayats, including coordinated spatial planning of the area, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. The overall objectives and priorities set by the Government of India and the Government of the state. The extent and nature of investments likely to be made in the metropolitan area by the agencies of the Government of India and the Government of the state and other available resources, whether financial or otherwise. Consult such institutions and organizations as the governor may, by order, specify. The chairperson of every metropolitan planning committee shall forward the development plan as recommended by such committee to the government of the state. Article 243 ZF. Continuance of existing laws and municipalities. Notwithstanding anything in this part, any provision of any law relating to municipalities in force in a state immediately before the commencement of the Constitution 74th Amendment Act 1992, which is inconsistent with the provisions of this part, shall continue to be in force until amended or repealed by a competent legislature or other competent authority, or until the expiration of 1 year from such commencement, whichever is earlier. provided that all the municipalities existing immediately before such commencement shall continue till the expiration of their duration, unless sooner dissolved by a resolution passed in that effect by the Legislative Assembly of that state, or in the case of a state having a legislative council, by each house of legislature of the state. Article 243 ZG. Bar to interference by courts in electoral matters. Notwithstanding anything in this constitution, the validity of any law relating to the delimitation of constituencies or allotment of seats in such constituencies made or purporting to be made under Article 243 ZA shall not be called in question in any court. No election to any municipality shall be called in question except by an election petition presented to such authority and in such manner as is provided for by or under any law made by the legislature of the state.